particularly, for instance, the United Nations Economic Commission for Africa has projected that the AfTA agreement has the potential of putting together the single biggest market, with the capacity of generating, 2.5 trillion gross domestic product. The ECA has also projected that by year 2050, the AfTA agreement also has the potential of bringing together 2.5 billion, population within the 55 African states. That is quite huge. That is quite huge by every standard. And what that implicates is that there will be a lot of, private international capital movement within Africa and from outside of Africa. And as we understand, international investment by way of international trade or international investment will always, go alongside international arbitration. And that throws up the relevance and importance of arbitration institutions. Now, we also understand from the treaty, the free trade agreement, that there is a dispute resolution mechanism that is, provided for, and which reflects the WTO model. But that dispute resolution mechanism also talks about settlements of dispute between government. The question then is, how do you resolve disputes between investors? How do you resolve disputes between investors and government? And that is why arbitration institutions now, their importance now is, becomes a lot more heightened. Those disputes that will arise out of those investments, out of those trades, are they going to be resolved within Africa? Are they going to be resolved outside of Africa? And will African arbitrators be involved in the resolution of those disputes? So these are, and a lot more, are the issues that will be engaged in, in this section. But I don't want to take the shine off the panelists. So let me yield the floor, to the first speaker, who incidentally is Milord, Honorable Justice Kanyep. His CV is already, put out on the WOVA page. If I have to read out his CV and that of other panelists, I'm sure I'm going to spend not less than 45 minutes in doing that. So all I'm going to be doing is just a summary of the respective, CV of the speakers. Justice Kayep, as I said, is the president of National Industrial Court. He has a PhD, from Ahmadu Bello University, and he's a man of many parts. He was with National Nigerian Institute of Advanced Legal Studies. He left that place as an associate professor, research. He's also a visiting professor, Benue State University. He has published a lot of books, and he has also written a lot of articles. So, Milord, you're welcome, sir. And
Thank
also,
you.
is also Dr. Salim. Dr. Salim also has a PhD and is the director or secretary general of the Cairo Regional Center in Egypt. Dr. Salim, you're welcome, sir.
Thank you very much, Mr. Madimir.
And also, Ms. Kimani, Susan Kimani, she has her first degree from University of Cairo. She has a master's with distinction from University of Cape Town. And at the moment, she also pursuing a second master's at Harvard University. She is a co-registrar of the Mauritius International Arbitration Center. Susan, you're welcome.
Thank you very much for having me. And
then there is also Mr. Ekatare. Mr. Ekatare is also a man of many parts. He's a lawyer by training, agri-economist by also training. He was a former judge at the Securities and Investment Tribunal, currently the registrar, the director at the Lagos Regional Center for International Arbitration. Honorable Ekatare, you're welcome, sir.
Thank you.
Now, Milord, I will invite you to please, give us an outline of what your thoughts are.
Masego from Kigali. Have I heard of him? Fideli.
Thank you very much. Dr. Fidel Masego, I am awfully very sorry, sir. I thought I had introduced you. Dr. Masego also has a PhD from Antwerp University in Belgium, and also is Secretary General of the Kigali International Arbitration Center. Dr. Masego, you're welcome, sir.
Thanks a lot, dear.
I'm sorry. So let me start by inviting my Lord Justice Kenya, the President of the National Industrial Court, to please give us an outline of what his thoughts are with regards to the role of arbitration institutions in Africa and what their contributions has been, with regards to socio-economic development of Africa. Milord, you're welcome, sir. I yield the floor to you now.
Thank you very much, and I extend my regards to my fellow panelists and participants. Some few days ago, I was going through some literature which tend to forecast economic development across the globe. And what interested me most was that in the next 30 years or so, the projection is that in terms of economic development, the surge will be in Africa, principally because of its population and principally because of its potential. Potential in terms of the natural resources and the energy, particularly the younger generation is bringing to bear. Now, if this is the projection, then of course, the saying comes into the fore. Where international investment goes, disputes invariably follow. It presupposes that we have to gear up in Africa to settling disputes that will come with the attendant investment. Now, even from the theme of the conference itself, we're asked to look at the arbitral process within the framework of free trade. Of course, free trade presupposes an ideology of capitalism. And one of the things that goes with it is the fact that because the dispute resolution system enjoined by the state, and here I mean the court system, is regulated at the level of government, it comes with it a certain level of disaffection, and consequently, people in consonance with free trade philosophy are eager to devise their own means of dispute resolution. And one of such means is, of course, what has come to be known as alternative dispute resolution, chiefly arbitration and mediation. Now, I want to bring to the table, apart from a general overview of the impact of arbitration in the social development of African countries, a thought or two in relation to labor. As a labor court judge, I just feel it right that I should end up my intervention with some issues dealing there. I attended some of the sessions from day before yesterday, and through to today. And what I hear being discussed in the main is commercial or investment arbitration. Commercial and investment arbitration. Now, coming as a labor court judge, and incidentally, my researches, and I have done a good deal of writings in the area of consumer protection, simply came up with what ideology underpins the resolution of disputes in relation to economic relationships. Now, when we look at economic relations, the tendency is to view it from a commercial setting, a commercial dealing. And because we look at it more in a commercial dealing, I need to make this point because a good deal of our discussion is going to be on commercial arbitration as distinct from labor arbitration. So after making my general remarks, I want to conclude with some concluding thoughts on that issue, that we should bear in mind that in as much as there is commercial or investment arbitration, there is the other side, arbitration that involves economically dependent people. And here I have people like labor arbitration, people who fall into what we call the economically dependent groups, or economic groupings that are not as powerful as their commercial counterparts. So, on a general note, arbitration as a dispute resolution mechanism, of course, contributes positively to economic development, whether introduced into a developing economy through individual commercial contracts or through bilateral investment treaty. Here, what we see is that it encourages foreign investment, and increased foreign investment leads to economic growth. I need to point out a preliminary point here. Once we are certain about rule of law, once we are certain about due process, and by this, I'm talking generally about the notion of access to justice. Once we are certain about it, and we make it one that is dependable, and people agree on it, it does not matter, even in the midst of insecurity, investments will come in. After all, even in war, there is what is called a war economy. So even the level of insecurity as we have in some African states will not be sufficient to stop foreign investment coming. What will stop foreign investment coming, and for me, as somebody who is a key player, is when the dispute resolution system in any particular given state or country is one that is questionable. Now, the positive impact of foreign direct investment on economic development will be multiplied if international investors are motivated by factors like I pointed out, like reliable dispute resolution mechanisms. Today, we find many areas of African economies still growing despite challenges due to sharp reductions in price of oil and other natural resources. In fact, most investors who are coming into Africa often choose between commercial arbitration or investment arbitration. In commercial arbitration, which is by far the more relevant category and which we are used to, the resolution of disputes relating to business activities, parties agree under a contract to submit their disputes to arbitration. Most commercial arbitrations are administered by arbitration institutions such as the International Chamber of Commerce or the London Court of International Arbitration. These institutions also provide parties with procedural rules, and commercial arbitration permits parties to opt out from state jurisdictions and mitigate legal risks where such are seen to exist. But to show the level of impact on socio-economic development, Africa accounts, the statistics goes, for about 836 bilateral investment treaties. So virtually all Africa-related bilateral investment treaties have provision for dispute settlement, and in the vast majority, they refer to investment arbitration. 45 African countries have been said to ratify the Convention of the International Center for Settlement of Investment Disputes. And when we look at the role of existing arbitral institutions in Africa and their continued relevance to the socio-economic development of Africa, I seek to make 3 points. 1, government have grown wise to the fact that arbitration can be a source of economic activity, with conference centers, hotels, and local lawyers all set to benefit. Secondly, for any country, a recognized arbitral center is also a great show of soft power, helping to underline broader messages about political and legal stability and give comfort to foreign investments, to investors. And thirdly, arbitral institutions operating within the continent are contributing to the development of arbitration in Africa, promoting their practice through events, attracting practitioners and arbitration users from the region and beyond. The increasing regularity of arbitration conferences in Africa, such as the one we are doing right now, illustrates the significant appetite amongst practitioners to develop skills and harness the growth potential of the African market. With that general statement made, I will move to the relationship between commercial arbitration and labor, just so as to justify my participation in this particular session. Like I pointed out earlier, once we talk about arbitration and other forms of ADR, mediation or conciliation, depending on the terminology we use, the tendency is to talk about commercial arbitration. Very often, we never put in sight labor arbitration. Here, you will have to excuse me because the bulk of the literature and the example I'm going to give will be essentially Nigerian because the problem appears acute here. Sitting as a labor court judge, I've had the opportunity to be asked to apply the Arbitration and Conciliation Act of Nigeria to a labor dispute. And my holding was that that act did not contemplate labor transactions, it being applicable only to commercial transactions. And of late, I have read remarks and write-ups by particularly the legal community that we may need to reconsider that stance because strictly speaking, the Arbitration and Conciliation Act applies even to labor disputes. For one or two reasons, I still want to maintain our stance that the ACR does not apply to labor disputes. For one, there is a legislation in Nigeria called the Trade Disputes Act. Under that particular dispute act, there is a section that is very particular in saying the Arbitration and Conciliation Act does not apply to trade disputes being decided under that act itself. That is one. Secondly, I draw analogy from item 34 of the exclusive legislative list in Nigeria under the 1999 Constitution of Nigeria. Under the exclusive legislative list, item 34, legislating power is exclusively the preserve of the National Assembly in respect of labor and incidental matters. And one of the specifically named incidental matters is industrial arbitration. Now, I want to believe that industrial arbitration and commercial arbitration are not the one and the same. In fact, I think it is drawing from that states like Lagos State in Nigeria could afford to enact their own arbitration law to govern transactions within the state. Now, that said, I go to the ILO, the International Labour Organization, with its decent work agenda. Now, decent work agenda simply...
Milord, I'm sorry to interrupt you, sir. Yes, sir. I'm sure you want to round up now.
Yes. The ILO decent work agenda hammers on what we call dignity of labor. And if you look at section 34 of the Nigerian Constitution, it deals with human dignity. And one of the provisions there is that you cannot, for instance, put anybody in servitude or compulsory or forced labor. The point being that under the decent work agenda, labor is never seen as a commodity for the simple fact that labor cannot be bought and sold. But when we talk about commercial transactions, very often we are dealing about services or goods that are being bought or sold, not necessarily within the framework of the realm of labor or the workplace itself. So all of this combined show that while it is necessary to discuss commercial arbitration, it is equally necessary to understand that there is another bit of arbitration, labor arbitration, which may require a different set of rules, different set of considerations when we deal with them. I just felt I should bring this to the table so that when we are discussing about the impact of arbitration generally on the economy, be it in Africa or be it domestically in our respective countries, we should understand that commercial arbitration differs from labor arbitration, and consequently, we may need to note that distinction and treat them separately. Thank you.
Thank you very much, Milord. Thank you for your very useful insights, particularly in trying to draw the distinction between commercial arbitration and labor arbitration. And I also made a note of the point you made, with regards to the significant pool that provision of arbitration, the effect it has on the movement of private capital. And that is not a statement that anybody can doubt, that the availability of arbitration or dispute resolution mechanism remains a major pool, to the movement of investment and trade, cross-border investment and trade, both within Africa and outside of Africa. So I thank you so very much, sir. I'm sure we will yet engage a lot more with regards to your interventions, on labor arbitration. Now, and I want to move on, having established this outline, and I want to move on to, to people who are involved in specific arbitration institutions across Africa. And I want to call on you, Susan, with regards to what your experience has been, in MEAC and also in PCA. What are your thoughts with regards to the role arbitration institutions can play, in economic development of Africa, and also keeping in mind the projections that have been made with regards to the effects of the free trade agreement? What has the story been so far, and what improvements do you see coming? Thank you. I yield now to you, Susan.
Thank you very much once again for having me and for my fellow panelists. I wish to share my screen if that is possible. I would like to speak to a few slides. Okay, is that visible from your end?
Yeah, it's clear.
Yeah. So I just pick up from where Honorable Justice Kanye left it, and the understanding is that arbitration does contribute to socioeconomic development. But the question that I asked myself is, how exactly does it do this? How exactly does the presence of arbitral institutions contribute to economic development specifically? Now, it starts from the bottom line that a country's economic development depends on a vigorous private sector and increased investment, as has been said. But for a country to have a vigorous private sector, it needs to have predictable and fair rules that govern business activities. And these rules must actually be enforced in order to protect legal and property and contract rights. And these then provides investors the assurance that if they invest in a country, disputes that arise in this context are going to be enforced in that country or elsewhere. And this contributes to the predictability of the cost of doing business in a country. In fact, there are some studies that have shown that a country strengthening its arbitration regime increases foreign direct investment and prevents the diversion of FDI to other countries. So arbitration, as one of the dispute resolution mechanisms, contributes to the enforcement of property and contract rights. Then this in turn increases the predictability of the cost of doing business in a country. And then this is what catalyzes business activity and investment in a country. And obviously this is subject to a caveat that there are other factors that will weigh in on the conduciveness of the business environment of a country. But it is true that one of the key elements is the presence of regulatory and enforcement mechanisms. Now I'll turn to Mauritius, which is my case study. Now, a substantial amount of foreign investment is channeled through Mauritius to finance operations across Africa and across Asia in different sectors. And these investments are made through special purpose vehicles, or SPVs, that are incorporated in Mauritius. And before the establishment of arbitral institutions in Mauritius, the arbitral clauses that were incorporated in the SPVs referred to foreign institutions. Some of them have been mentioned by Justice Kanye. But since 2008, the Mauritian government has taken proactive efforts to launch Mauritius as an arbitration hub, and it led to the establishment of the first PCA office, the Permanent Court of Arbitration office outside of The Hague, that was established in Mauritius in 2010. And later on in 2011, the government of Mauritius, together with the LCI MIAC, entered into a joint venture that formed the LCI MIAC Arbitration Center, which was later on dissolved to form MIAC. And thirdly, we have the dispute resolution arm of the Mauritius Chamber of Commerce and Industry, that is MIAC. So together, these three institutions operate in Mauritius, and they provide viable alternatives to the traditional foreign arbitral institutions that have been utilized to resolve disputes arising in SPVs. So you see more and more arbitration clauses referring to Mauritian centers, and that's already an advantage. And there are hearings and proceedings that are being carried out arising out of these contracts, that there are hearings and proceedings that are referring now, or rather being carried out under the auspices of Mauritian arbitration centers. Now, just to give you a taste, just a year after launching of these arbitration facilities by MIAC that were launched in November of last year, MIAC has already hosted 4 in-person hearings, and this is in a year in which we have a pandemic and we know the difficulties of holding in-person hearings right now. But the center has managed to attract in-person hearings, and a couple more are scheduled to be held, and we predict that these are going to increase as we come out of this pandemic period. And the other benefit that the arbitral institutions have brought in Mauritius is that they provide services at lower administrative costs while maintaining an international standard to professionalism, to facilities, and to their services. And while the lowering of the administration cost is already an advantage, the convenience and the time efficiency of holding hearings in the jurisdiction where the business is, where the lawyers are, or the region in which these businesses are located is also another added advantage to having arbitral institutions in a country or in a region. And you can imagine that absent of these centers, arbitration proceedings and hearings would continue to be held in foreign arbitral institutions, as they have been in the past. And so these centers are also contributing to what we call the delocalization of arbitration from Africa, where African disputes are held in different regions or in foreign centers. So the centers are contributing to this, and not only Mauritian centers, but centers in other countries in Africa. I was quite interested to see whether this conducive business environment that comes with having arbitration, having arbitral centers, has contributed in terms of figures. And so I looked at the numbers of foreign direct investment inflows in Mauritius 10 years ago, so back in 2009, before we had the centers. And at that time, FDI inflow in Mauritius stood at 256 million. And 10 years later, FDI last year stood at 472 million. And obviously these factors, this change and these figures that have now nearly doubled can be attributed to other factors. But I will argue that the favorability of the business environment that comes with having good regulation and good enforcement is a key factor that contributes to this near doubling of the figures. And another interesting factor is that over the 10-year period, Mauritius has risen from position 21 to position 13 on the World Ease of Business Doing Index. Again, this could also be attributable to other factors, but having good regulation, enforcement of contracts is a huge contributing factor, and that we hope is going to continue contributing to Mauritius becoming a better or easier place to do business. The other way that the arbitral centers have contributed is that they raise the visibility of the jurisdiction as a dispute resolution hub. If I ask you 10 years ago, 15 years ago, if you mentioned arbitration in Mauritius, whether you could ever put those two together, probably not. But because the three centers have actively promoted the jurisdiction as an arbitration venue, it has raised the visibility of the country as a dispute resolution hub. Now, the positive reports are not only interesting for disputants or people who are looking for a venue for arbitration, but it also sends a positive signal to investors that Mauritius is a safe jurisdiction for investment, because there is the ability, they have the ability to provide legal security of their contracts. And a final point as I round up is that arbitration centers also bring about direct financial inflows to the economy. And I thought that it would be interesting to bring this closer home, but by looking at a fictitious Nigerian arbitration case, and to see how the money circulates in the economy. You see, parties are going to retain counsel to represent them, so there will be money flowing to counsel, maybe in Lagos or in Abuja. You have arbitrators billing for their fees and expenses. You have the arbitration secretariat that is also billing for the services that they're providing for the use of their hearing facilities in different locations as well. You'll also be utilizing expert witnesses. You'll be using support services, transcribers in most cases. Now we're also heavily relying on audiovisual technology, such as we are for this conference. And the food and beverage industries also benefits. The transportation industry also benefits in cases of in-person hearings. And so you can see that the impact is not only limited to the legal sector, but it's expansive to the general economy of a country. And the picture becomes even more interesting and more expansive when you have an international arbitration, because then the inflows are not only local, but from foreign counsel, foreign arbitrators. You now have the picture expanding to capture flights in and out of the country. The hospitality industry benefits because you have people utilizing hotel accommodation. People will take, even in cases of conferences, people will take a few days after the conference to tour the country to see the nature. And also in the legal sector, then it is more expansive because you might have a hearing that is in 2 languages that requires interpreters and translators. So then the picture becomes quite interesting when you have international arbitration coming into a country, or international hearings coming in or being held in a country. And in addition to this, you have arbitration centers generating employment for local counsel, work opportunities for interns. So there's a huge sort of microeconomy that surrounds arbitration institutions and proceedings. And I'll leave it at that. Thank you very much. I think you're still muted, Mr. Madumere.
Thank you very much, Susan, for your intervention, which is very insightful. And I mean, you have tried to link, the availability of arbitration and arbitration institutions, to increased flow of foreign direct investment into Mauritius. Looking at what it was in 2000 and what it became 10 years after, it kind of more than doubled. And you've also tried to point out other important points, that may have also contributed to, the increased favorable investment climate in Mauritius. And but one question I want to ask you, Susan, is of course the point you have made with regards to economic development is well noted. I mean, and the direct financial inflows that arbitration has brought into Mauritius is all good. And the visibility arbitration has given to Mauritius is also all very good. But in terms of human capital development, I'm sure you are aware that one of the topical points that has remained very, germane in arbitration circles is issue of diversity. What has been the experience of MEAC in addressing concerns about the low patronage of African arbitrators in African disputes, particularly those that are conducted under the auspices of MEAC? Thank you.
Thank you very much. That's a great question, and that remains a concern not only at MEAC but across regional arbitration centers. The underutilization of African arbitrators, the lack of gender diversity, even when it comes to the pool of African arbitrators. So what MEAC has done recently is to establish a database of arbitrators, not only in Africa, but really focusing on Africa, African arbitrators, Asian arbitrators, but also globally. And this is a database in which we invite people who are arbitration practitioners to put themselves up, put the information there. We are going to avail it. It's going to be an online open source database where any disputant looking for an arbitrator can access it free of charge. And this is a way of, showcasing African talent. This is a way of showcasing who's available, what is the experience. And there's also an increased use of African arbitrators. It's not where it needs to be by far, but while the appointing authority is hiring, or rather appointing an arbitrator, they will look at obviously the dispute, its context, its parties, its locality, and while considering the arbitrators to be appointed, we'll look at African arbitrators as well. And that is a practice that I can confirm is, it's happening at MEAC, it's happening at the PCA as well. Yeah.
Thank you very much.
If I may just also add one point, is that we're also focusing on training quite a bit, not only of arbitrators, but also at the judiciary, because it's quite important it sends a strong message if the judiciary is also pro-arbitration or pro-enforcement.
Thank you very much, Susan. Thank you. And I will come back to you, on the last point you made. But before I do that, let me go over to Dr. Fidel Masingo. Dr. Fidel, I'm sure you want to make your contributions at this point. And the question to you is, what has been the experience of Kigali International Arbitration Center, and what has been the socio-economic contributions of KIAC so far? And what do you think is the potential that KIAC has with respect to its contribution in the light of the potentials we also see in the free trade agreement? Dr. Fidel, over to you. Dr. Fidel, are you there?
Yeah, I'm there. I'm there. I'm not sleeping. I know it's every morning here. It's 5 a.m., but I'm awake and I'm willing to just respond to your question. Thanks a lot. I think I will not very differ with what my colleague has said. There are really a serious reason to associate arbitration, international arbitration, and economic growth, economic development, and arbitral institution play a key role in this. As you know, as international investment and trade on the African continent is growing, the number and frequency of commercial and investment disputes in Africa have inevitably increased. Yeah, so in recent years, the number of commercial arbitration cases have increased in Rwanda. Not only in Rwanda, but you've also seen this in many other parts of the world. As you know, despite this growth, Africa-related disputes have kept lawyers busy for a number of years in traditional arbitration centers such as International Chamber of Commerce, the London Court of International Arbitration. As you know, when you see the report of the caseload of ICC of 2019, you will see that the ICC itself had 130 cases involving sub-Saharan African parties, which accounts for 5% of all parties in its 2019 caseload. When you also go to London Court of International Arbitration, you will find that in 2019, more than 10% of the cases involve African parties. So the same with, exceed. I don't want to go into details, but you will find that that's 22%. So based on this, many countries, establish their own arbitral institution. We have nearly 100 arbitral institutions in Africa. And in those arbitral institutions, you include also KIAC, which is Kigali International Arbitration Center. In fact, within the past years, Rwanda government and Rwanda Private Sector Federation have realized that arbitration is gradually becoming an indispensable condition for the development of African economies. And we just created a center, and the creation of the center has contributed to access to justice and has reduced the backlog of cases in the court. Since its establishment, KIAC has set out its bold ambition to become the reference point for international dispute resolution, not only in the region, but also for the entire African continent. And, KIAC started by appointing foreign board members to make sure that we are strengthening the center's independence, the credibility, and the regional and international influence. This was done with a purpose. We also recruited, I can say, world-class arbitrators to make sure that we have panels that can not only serve as an alternative, but serve also as a premier choice for, African parties, especially those in the region. Speaking on the reason of creating the center, before linking it to the work that he has done, in Rwanda, as you know, the first issue to mention is the issue of cost. That has been mentioned even by my colleague. So many arbitration conducted under the eyes of Western institutions have had challenges of those, costs. Local client and counsel have several times stressed the fact that it's very expensive to conduct arbitration, at ICC or RCA. For example, filing a claim at ICC is $5,000 US, while doing it in Rwanda is $250. You understand that it's like 5%. So if it's 5%, we save the costs. The administrative costs can go up to 150,000 at ICC, while it can't exceed 23,000 when parties have chosen KIAC. So by choosing to file a case at KIAC, local and regional economic operators save also transport fees and very expensive Western hotel cost. That's one. Number two, KIAC, as well as functioning arbitral institution, has been generating some economic gains. In fact, securing the arbitration of international arbitration dispute is now turning the country to be a hub for arbitration. There are also other economic related activities that can be mentioned. I can mention, renting or hearing, the hearing rooms, promotion of local hotels, possibility of using local law firms. We've even had international law firms established in Rwanda for the first time, court reporter services, customers who use Rwandair as their carrier. So I can say many things, but I just want to also associate this with the World Bank doing business report, especially on what is called enforcing contract. If you see how Rwanda has been doing for the last 5 years, just after the establishment of the center, you will find that Rwanda has been ranking #2 in Africa after Mauritius. Last year, we ranked 38 out of 190 economies. So I can't say that it's all attributed to the arbitration center, but KIAC also plays a key role, especially in enforcing contract. I just also want to let you know that since the establishment of the center in 2012, we've had more than 160 cases. And those cases involve more than 150 million US dollar. And remember, this is a non-judicial mean resolution dispute, which is done within a short time. To us, it's really, it speaks a lot for, economy. When you see the cases we had, or even those we have now, is construction, services, you understand that the center is also playing a role in accelerating, dispute and making sure that investors can, keep their day-to-day activities. When you see the parties that have involved in those cases, you realize that, we have more than now 27 countries, including China, Egypt, France, India, Italy, Kenya. I can't give the whole list, but you understand that it also means a lot for the economy, because all those people that are coming, it shows something in our economy. And like for only last year, the geographic origin of the cases, 33% were foreign cases, while 67 were domestic. So you understand that 33% of international cases, it's a good number. Before concluding, one can also mention capacity building of arbitrators. Before the establishment of Kigali International Arbitration Center, no single arbitrator was trained in Rwanda. Today, more than 500 professionals have been trained in arbitration by the Chartered Institute of Arbitrator. We now have a Chartered Institute Arbitrator branch in Rwanda. So I can just conclude by saying that with this also, we've also organized many conferences, which also play a role in economic development. The last 3 years, we've hosted the conference by the East Africa International Arbitration Conference in 2017, the 2019 SOAS International Arbitration Conference, and the 2019 Annual International Arbitration African Arbitration Conference. So all those activities have an influence, a positive influence on economy. That's what I can say now, but I can say that there are many contracts that are including KIAC arbitration clauses, and we hope to have many cases in the future. I think I can stop there to allow others to talk as well.
Thank you very much, Dr. Fidel. And it's so good to know that the Kigali International Arbitration Center has done so very well within the short lifespan that it has enjoyed. And good to know also that is evolving to becoming, a regional hub, within the East African sub-region. But before I let you go, Dr. Fidel, I need to ask you a question. The young members group of the Charter Institute, is a very important group that the CIAP takes plays a lot of premium on, because particularly for we as Africans, in view of the fact that a lot of Africans have argued that the disadvantage African arbitrators have had compared to other people from other countries or continents is because people didn't start early enough, and people don't have enough, opportunities early enough. And now my question to you, Dr. Fidel, is there anything that in CARE that tries to promote, young arbitrators within the African continent, that as a matter of policy, maybe a mentoring program or a facility that allows young members to gain useful experiences while you are doing your work in Kigali? Thank you.
Yeah, it's in our policy to train young arbitrators. Actually, arbitration is new in Rwanda, so we all are learning, and we used to, invite people to come to our center as interns, and we've had many interns, including some interns from countries like UK, interns from, Cameroon, we've had interns from Uganda. I can say like 70% of our interns come from Africa, which is a good thing. Number two, we have also, a program of mentoring. We are trying to see how to engage those who have been trained to be able to attend some hearing, but it depends with the parties. You have to just ask for the parties to allow them to come. Of course, they sign confidentiality, statement, but parties can allow them to come and attend some of the hearing. It's a way of, mentoring them. But also, we have what we call the Institute for Legal Practice and Development, which does train, lawyers, arbitrators, and prosecutors and judges. And KIAC, together with the Institute, do organize a course on arbitration. And it's meant to, it combines both, oral teachings and what I can call moot courts. So this is a way of trying to make sure that young arbitrators are well acquainted with arbitration and that they are involved at early stage. That's what I can say now. Yeah.
Thank you very much, Dr. Fidel. Thank you so very much, and it's good to know that such program is being put on the table by KIAC. Before I invite the next speaker, who is going to be Dr. Salem, before we started, there was a poll that was put out, for people to vote and people to give their thoughts as to whether how the African arbitration institutions have fared so far. From the result we have received, it doesn't look too good, but at least it's a starting point. 18% says very good, that African arbitration institutions have done, very, very well. Then 49% said just average. Well, whether average is a pass mark or so, I don't know. Then 21% says below average. 11% says not sure. People should continue to vote. I will still read out the results at the end of this section. Now, let me go on to Dr. Salem. Dr. Salem, please give us your insights as to what your experience has been with the Cairo Regional Center in terms of its contribution to socio-economic development of Africa. And also, I want you to speak also, with regards to your caseload and what the experience has been with regards to diversity, in terms of getting African arbitrators on board, and also in terms of training facilities that you are putting in place in Cairo to ensure that African arbitrators, gain insights and gain useful experiences, going forward. Now, the floor is to you, Dr. Salem.
Thank you very much, and good evening, ladies and gentlemen. I'm very thankful to the Chartered Institute of Arbitrators Nigeria branch to have invited me. It's truly a pleasure. I will talk with you about the role of the Cairo Regional Center for International Commercial Arbitration, and the acronym is CERSICA, in the development of arbitration in Egypt, part of North Africa, and in Africa in general, because we have also tried to reach all the different regions of Africa and to do our best in order to cooperate and to contribute in the development of arbitration throughout the continent. The CERSICA is one of the success stories that we have seen today, like Kigali, KIAC, like OHADA, like the NCIA in Nairobi, like MIAC in Mauritius, and the Regional Center of International Commercial Arbitration in Lagos. One of the reasons of our success is that we have not been established as an Egyptian entity. We have been established as an international non-governmental organization, and Egypt is the host state. So our source or our parent organization is ALCO. ALCO is the Asian African Legal Consultative Organization. It comprises 46 member states. All of them, except one country, are African or Asian states, except Cyprus, which is the only European country of ALCO. In the 1970s, ALCO has done several sessions in different countries, and the thinking was that international arbitration, including with respect to disputes involving Asian and African countries at that time, was exclusively taking place in Europe and America, and was decided upon mainly by arbitrators from the northern countries in Europe or in the United States in America. So the idea was to establish regional centers in Asia and Africa, and at the Doha session in Qatar in 1978, a decision has been taken to establish two regional centers, one in Kuala Lumpur, the KLRCA, which became now the Asian International Arbitration Center, and the second one in Cairo in 1979. The Cairo Regional Center was established in 1979 by virtue of an agreement between ALCO and the government of Egypt. Then 3 other centers in the Afro-Asian region were established. The third one was in Lagos, so represented by my dear friend, Mr. Ikatari, and then in Tehran, in Iran, and then the NCIA in Kenya, in Nairobi, which was established, to the best of my knowledge, in 2010. What the CERSICA has achieved in Egypt, the host state, and in the rest of Africa. In Egypt, there has been relatively a delocalization of international arbitration. Before CERSICA, all the arbitrations, international arbitration cases involving Egypt, were seated abroad and administered mainly by the ICC or the UNCITRAL ad hoc, but outside Africa, outside Egypt, it was taking place in Europe or in America. After the establishment of the CERSICA, this has started to change. Mainly, the most important thing to achieve in order to ensure this delocalization is the neutrality of the institution. So CERSICA, from day one, has tried to project a true image of neutrality through the diplomatic immunity of the institution. The institution enjoys immunity and privileges, ensuring its independent functioning vis-a-vis the host state. And the foreign investors, since from the first case, an Egyptian public entity lost the case against a European company. This was the first case registered at CERSICA. It was the case number 1 for the year 1983 or 1984. Excuse me if I can't remember. But you see, the first 4 years there was nothing. The first 14 years of CERSICA, so from 1979 until 1993. The CERSICA registered only 42 cases, which is an average of 3 cases per year. So this was a very low caseload at that time. How things started to change? Things started to change in 1994, when the Corsica strongly contributed and pushed the Egyptian legislator to adopt a model law legislation. So the Corsica itself adopted rules very strongly inspired by the UNCITRAL rules. So this was a clear indication for the foreign investors that the Corsica is adopting modern rules. And at the same time, there was a need that the jurisdiction itself adopts a model law based legislation. Since 1994, the caseload started to grow. The caseload currently is, so last year we have registered 82 new cases. I believe that this caseload can grow compared to Egypt, which is a country, the population of Egypt is 100 million and 2 million. So the number of Egyptians, the Egyptian population is big. It's the second biggest population, or the third after Nigeria and Ethiopia in Africa. So we have a potential to have more cases with the growing Egyptian economy, whether the Egyptian international market or the Egyptian domestic market, because the domestic market, I would mean purely domestic arbitration, and the international market would be the cases involving international parties versus the Egyptian parties. So the Corsica to date has administered 1,440 cases. The Corsica was able to develop the Egyptian jurisdiction through its dialogue with the local courts. Egypt, so the Corsica has organized the sole biannual conference on the role of state courts in international arbitration starting from 2002, where then this conference focuses on the role of state courts in international arbitration. And it is very important that the local courts are friendly vis-a-vis arbitration and do not annul arbitral proceedings except in exceptional cases where there is an issue of due process, no revision of the merits of the award, and a narrow construction of the public policy defense. The cooperation, so this is with respect to the Egyptian jurisdiction. I would add something that we as Egyptian, the existence of Corsica on the Egyptian soil was a benefit to us because it has given us, and I would say you know very well, very big names as our Egyptian arbitrators, Egyptian African arbitrators, like Mohammed Abdul Wahab, like Mohammed Abdul Raouf, like Karim Hafs. I don't want to mention specific names, but there are many. Myself, before becoming the director, the first appointment as arbitrator, we got it from Corsica. I was appointed as arbitrator the first time in my life. I was 31 years old. And I believe that I was very lucky to be appointed for the first time in such a young age. I think the major factor is that there is an institution, a very well-established institution on the Egyptian soil that has given me this opportunity. If we speak about the role of the Corsica in Africa, I would agree with you that at the beginning of Corsica, the image of Corsica was that it is an institution established in the MENA region. And this is true, the influence of Corsica in the MENA region, and because we speak Arabic, we are Africans, of course, as Egyptian, but we speak Arabic. So we also have strong ties with the non-African Arab countries, as well as the North African countries speaking Arabic. But then we have gradually moved to have stronger ties with Sub-Saharan Africa and Sudan, of course, which is both, it is in Sub-Saharan Africa, and they also, our Sudanese brothers, they also speak Arabic. So this has also helped. So if I say some examples of cooperation of Corsica with Sub-Saharan Africa, I would mention, for example, the cooperation between Corsica in 2001 and then the training courses and the African Center for Legal Excellence in Uganda, which is the center of the International Law Organization. Then I will have to mention when I took over the helm of the Corsica in 2017, and due to the support of my predecessor, we started cooperating with the SOAS series of conference, and we hosted the SOAS conference and Dr. Emilia Onyema. It was a conference on the role of African states and governments in the development of arbitration in Africa. It was in April 2017. Then another conference with
Dr. Salim, I'm sorry to interrupt you. Please, could you just round up, I beg you, for the reasons of time.
I will mention one last thing is the appointment of arbitrators from the sub-Saharan Africa. I think this subject is important and I'm very frequently asked this question. So I will give you examples, for example, from 2017, and I think this was new. We have appointed an arbitrator from Nigeria. So Nigeria was the first country from sub-Saharan Africa, and then from Sudan. And then it was easy. We appointed several arbitrators from Sudan, and especially whether cases pertaining to Egypt or cases pertaining to Sudan, seated in Sudan. Then this year, we have appointed an arbitrator from Nigeria, a young arbitrator, so a similar opportunity that the one I got when I was much younger in 2006, an arbitrator from Tanzania. And then we have a presiding arbitrator appointed by two co-arbitrators, not by the institution, from Tanzania also. Of course, there are barriers to diversity. If we speak about diversity, it is linguistic. Most of our caseload is in Arabic. 70% of our caseload is in Arabic and only 30% is in English. It is slightly changing. This year it's 50-50. There is also another barrier during the rules are based on party autonomy. So you can compare some institutions. There are, for example, the ICC and the LCIA, the institution has the upper hand in appointing the sole arbitrator or the presiding arbitrator. This is not the case, except if the parties agree otherwise in the arbitration clause with respect to ICC. With respect to Corsica, the rules are UNCITRAL rules based mainly on party autonomy, and the institution appoints only if the two co-arbitrators fail to agree on the presiding arbitrator, or if the respondent does not appoint its arbitrator. So these, I think there are barriers to diversity. There is also the cost of traveling. Sometimes you have the user requesting that the arbitrator is residing in the seat of arbitration. They don't want to bear the cost of traveling. So every institution is trying to diverse. We have also, we regularly publish statistics on the number of arbitrators below 40 who have been appointed, and the number of female arbitrators. We have also signed a pledge to appoint female arbitrators. So any institution tries and strive for achieving diversity, but at the same time, there are some barriers to it. So this is what I wanted to mention. I think it is important for the audience to hear about it. And I saw there was a question about that. So thank you very much for the time you've given me. And I give you the floor.
Thank you very much, Dr. Salim. It's so good. It makes me a lot happy to hear that, you know, the role you played in turning the tide around, you know, starting from 1994, when you were ensured that in a favorable legal framework was put in place in Egypt. And that establishes beyond doubt that once a favorable legal framework is in place, I mean, every other thing falls in line. And it's also very good to know that, you know, the role you played in ensuring that you get the buy-in of the state courts into the arbitration process, and also the fact that you have in place also programs that ensures diversity, particularly with regards to encouraging young practitioners, you know, to grow, and that is very important. And that takes us to the last speaker today, of course, no less the least, Honorable Ekatare. Sir, could you, in 10 minutes, particularly in the light of the submissions of Dr. Salim, you know, with regards to how, you know, involved the regional center in Cairo has been in ensuring favorable legal framework and ensuring, you know, the buy-in of the state courts into the arbitration mechanism, and how it has turned things around in Egypt. Could you please, in 10 minutes, give us your insights? What has been the experience of the regional center in Lagos been, and how have you been able to impact socio-economic development of Nigeria and of course, Africa. Thank you, sir. You're on mute, sir. Could you please unmute yourself? You're on mute, sir. Unmute yourself, sir. Sir,
Okay.
please. Thank you.
Thank you so much. I thank you so much. First of all, I have to commend the Honorable Justice Kanyib. I was so interested in that area. I say one thing he mentioned that anywhere an arbitration institution is located, it is a center of prestige and of big economic value. And that is true of Karika, Miag, and Kigali. I know that you've emphasized 10 minutes, 10 minutes, but you must realize that the way we are given to do, everybody brings something to the table. What I see from what we are given to talk about, like when the way it was composed, is two different things. And it's so large, but we've been able to do something, justice to it. Arbitration as a private mechanism for the resolution of a dispute between parties definitely has legal, economic, and social implications in the economy of any nation. In other words, where arbitration is made accessible in the resolution of domestic and international disputes, its legal, socio-economic impact on the economy of any country on the continent of Africa is undisputable. The potentiality of arbitration institutions in Africa, although not a lone factor, offers a recognizable window for the attraction of increased commercial and investment activities all across Africa. Africa holds a huge market, just like Honorable Justice mentioned, for primary, secondary, tertiary economic activities amidst a dynamic demographic factors necessary for socio-economic growth and development. So use of arbitration has amazing rapidity. This year has been on the rise, amazing rapidity. Therefore, the significance and relevance of arbitration institutions to the increased commercial investment inflows into and within national jurisdictions in Africa can no longer be underestimated. The potentiality of this beneficial scenario underscores the fundamental criterion that newer arbitration institutions have dotted the entire landscape of Africa in recent years. The establishment of these institutions, either owned by government or individuals or a company or international organization, like my colleague in Cairo had already mentioned, is an example. Like we, an arbitration institution, was established as already he had outlined. Just to say that the bottom line is that either it is there to promote capacity building or a combination of, or to handle all these commercial disputes by way of institutional and ad hoc arbitration, whichever way. All are contributing factors to. However, the regional center, for instance, in Nigeria, is an arbitral institution of international character established by, like mentioned, ALCO, that is 48 members state intergovernmental organization. Pursuant to its program on the economic field, launched an integrated scheme for the settlement of disputes in economic and commercial transactions. 78. The objectives of the center as a non-profit making institution is to promote international commercial arbitration, especially the adoption and use of central model law and rules in the region, and to coordinate and assist existing arbitration institutions, conduct institutional and ad hoc arbitration, enforce and assist to enforce arbitral awards, and maintain register of international panel of arbitrators. You see, one of the fundamental reasons for putting our institution here is to encourage our own, let me call it in quote, our indigenous arbitrators. Because the tendency for it not to be too pale, too much Western, it is important that we bring up our arbitration landscape by engaging our own indigenous arbitrators. And that is one of the cardinal points of the regional center. And if you look at our own panel, you will see that major emphasis runs across Africa, Asia, then some parts of the West, right, all that. So the roles of existing arbitration institutions is the promotion of arbitration or other ADR Then to provide modern rules to meet the concerns, flexible enough to accommodate varied interests of users in commerce, investors, practitioners, vis-a-vis public policy requirements of different national jurisdictions, providing modern infrastructure, facilities made available for easy access to key players and stakeholders, encouraging promotion and appointment of African arbitrators and practitioners. Very, very important. In addition to that, arbitration institutions also encourage capacity buildings and practitioners and in other allied, both general, commercial, and specialized aspects, like for instance, marine and shipping arbitration and other areas. So the continued relevance, as earlier mentioned, arbitral institutions exist and operate in the context of fabric of socio-economic ecosystem. In other words, arbitral institutions do not exist and operate in isolation. Therefore, their continued relevance and remarkable contribution to socio-economic growth and development on the continent requires a collective responsibility of individual states, arbitral institutions, arbitrators, arbitration stakeholders, and users. Now, for instance, the state, for any arbitration institutions contribute relevant to socio-economic growth and development of emerging economies in Africa, the state has a key predictable role to play in putting in place what I call the three arbitration friendlies. One, arbitration-friendly national policy. Two, arbitration-friendly legislative framework. Three, arbitration-friendly judicial system. See, a national policy must put in place a government-driven arbitration-friendly national policy that prescribes guidelines that recognize and accept arbitration as a necessary tool for dispute resolution as an integral part of ease of doing business. Policy guidelines that address the concerns of public policy issues, offers assurance to investors and entities engaged in commerce and investment. Powers arbitration institutions, provide infrastructure and funding where applicable. Public policy guidelines that widens access to justice for investors and clients. Also, policy guidelines that commit the legal structure and legal system to recognize and support arbitration for dispute resolution in intra and inter-border investment and commercial disputes. Now, the legal structure. Arbitration-friendly legal structure ensures that the legislative framework, which provides a stable, transparent regulatory certainty that investors and traders need, that allows parties equal treatment and free choice of their own counsel in event of disputes, and of course, that meets international standards. Judicial system. As a corollary, judicial system of any jurisdiction considered arbitration friendly, where it's recognized and accepted as appropriate mechanism for dispute resolution. If the judiciary of that country did not recognize and accept that arbitration is an appropriate instrument for dispute resolution in either domestic or international arbitration, the judiciary that has
Honorable sir, I'm not sure we can hear you again.
Institutions. Arbitral institutions remain relevant to economic activities across jurisdictions in Africa in remarkable ways. Their capacity and capability are better enhanced where, number one, their municipal statute grant institutions adequate funding or independence where applicable to operate without interference from government. Administering the institution professionally by way of adoption of modern ancestral rules, standard infrastructure, good facilities, deployment of modern technology in the delivery of international standard services in line with best practice. Arbitration institutions that admitted modern rule and deliver quality service and facilities, as well as ensure the fairness and integrity of arbitration process become a signature of entities in commerce, investors, arbitrators, and other users.
Honorable sir, I'm sorry to interrupt you, sir. I'm being reminded that we have just 6 more minutes and we need to round up, sir. So I will give you 2 more minutes, sir.
Well, thank you. By Article 4 of the Washington Convention of 1965, a person of high moral character, arbitrators are persons of high moral character and recognized competence in the field of law, commerce, industry, and finance. You see, what I want to emphasize is that for arbitration to remain relevant on the continent, it is better and also quite recommendable that our arbitrators must be persons of high moral character, must uphold the integrity of the process, must ensure that they are devoid of other sharp practices, devoid of all these dishonest practices in order to promote and engender confidence in the process. I would have gone further to even examine the institution contribution to socio-economic development, which are quite there, because you see, when you talk of arbitration as an institution to engender either infrastructural or whatever investment we want to embark upon, it must be understood that the bottom line is that arbitration offers a platform where the macroeconomic indices, patronizing hotels, flight arrangements, transportation, and local industry and the insurance companies and all that comes to play. Their microeconomic level contribution collectively to the economy. However, it is understood that at the macroeconomic level, the collective activities of these micro indices give rise to economic growth and development, because they impact the gross domestic product, which is the total services provided, which arbitration institutions in Africa have to a greater extent been able to perform that role. Now let me mention, by way of closure, when it comes to development of the capacity of arbitrators on the world stage, here in Nigeria particularly, we must commend the Chartered Institute of Arbitrators, who are the host of this very conference. They have done so much in that field. And because of the level of their involvement in capacity building, knowledge transfer, it has increased the welfare, the well-being, because there is a multiplier effect into the economy of not only Nigeria, in the sub-region, and Africa as a whole. Because right now, today, that institution can be proud of well-qualified, seasoned, built arbitrators that can stand anywhere on the global stage. And
thank you very much, sir. Thank you very much, sir. Thank you so very much, sir. And let me, on behalf of the Chartered Institute, also express our thanks to the panelists for finding time, to come and make these useful contributions today. And the high points of our contributions today remains that African arbitration institutions are poised to play in the roles that they are supposed to play. They recognize those roles, and they've been playing it, from influencing federal legal frameworks to putting in place, policies that ensures the buy-in of the judiciary, and also putting in place policies that ensures diversity and the growth of our young members within Africa. So thank you so very much, everyone, for coming. Let me now call on the chairman of the CPC, Mr. Mikhail SN, to please take over from here.
Thank you very much, Chief Madumere, Chartered Arbitrator, for this wonderful and intellectually engaging session that you've just moderated. I would like to use this opportunity to thank the panelists, the speakers that we have on this session. My Lord, Honorable Justice Bibi Kanyi, my big brother and my teacher, Dr. Ismail Salim, Susan Kimani, Wilfred Ikatari, and Fidel Mosengo. We are not surprised at what we received this afternoon from the interactions and the conversations that you had on this session. We thank all of you for the sacrifice, for making out time to be here and speak to us. We know all of you have a lot to share, but for the time that we have, We make sure that by the special grace of God, given another opportunity, would also invite you again to come and share your wealth of experience and knowledge on this topic and maybe some other topics as well. Most of all, let me use this opportunity to again appreciate all the participants in all our sessions thus far. We still want you to remain on the platform. We have our virtual induction of different cadre of membership of the Institute coming up at 4:15. We appreciate you for being a part of this conference, without which we really wouldn't have had a conference. So thank you very much for being here, my lords and distinguished panelists. We appreciate you. My younger brother, the coordinator of this session, Mr. Zuberi Dusa Ali, thank you very much for all that you have done. The Institute is happy. We're all happy. We are better educated. We are better persons than we started this conference. We thank you